Are we all here? All right. This is Judge Eric Shepard presiding in Travis County Court of Law number 2. I'm calling this hearing to order and cause number C1CV2400475 Aubriana Luck versus Johnny Johnson. The date is Thursday, January 9, 2025. This hearing is being conducted remotely on Zoom and live streamed on the court's YouTube channel. No recordings of this hearing are permitted other than by the official court reporter. Any violations of these instructions are punishable by contempt. If you would announce yourself for the record, tell me who you represent and whether you're the movement or respondent in today's hearing.
Good afternoon, Your Honor. Ali Akhtar representing the movement, Johnny Johnson.
All right.
Aubriana Luck representing myself.
All right.
And yeah.
All right. Mr. Akhtar.
To proceed?
Yes, sir.
Okay, thank you. All right, Your Honor, I represent Johnny Johnson, who is the owner and landlord of a condo property on Burton Drive in South Austin. Ms. Aubriana Luck was the former tenant in that property, or was one of the former tenants in that property. This is an appeal de novo by her from a JP court case that she initially brought, where we received summary judgment there against her claims and also attorney's fees. So I guess now she's appealed again. So we're again moving for summary judgment against all her claims as a matter of law. I'll start by putting up on screen. This is her petition that she filed in JP court, and I'm showing this because she has never actually filed any amended pleading or any new filing in this case. So this represents what her live pleadings are in this case. So she filed this in February of 2024, and this is her complaint that I'm circling right now. Essentially, her complaint boils down to 3 distinct claims. One, she's claiming that she had a valid right to terminate the lease with my client under the domestic and family violence exception, which is noted in the Texas Property Code, Chapter 92. That gives a tenant the right, upon presentation of one of 7 categories of documentation, that if they've been the victim of domestic or family violence, they can terminate the lease early without penalty. Second of all, she's gone back to sue months after leaving the apartment. She's gone back to sue for all of the issues that she believes were unsuitable or uninhabitable during the time that she lived there. If you see the narration in her complaint, she thinks that repair conditions were unremedied and damages weren't taken care of, so she wants to go back and sue for thousands of dollars of damages. Thirdly, she claims that she's entitled to get all her security deposit back, even though she left the lease early. So that's what her 3 claims come down to in this case. So I'm going to start by showing as a matter of law, we're going to show that there are no disputed issues of fact. It's an undisputed fact record, and all 3 of those claims fail as a matter of law, and my client is entitled to summary judgment. So I'm first putting up on screen what we've already submitted to the court as Defendant's Exhibit 1, and this is the actual lease. So it's undisputed that Ms. Luck and her then roommate/boyfriend, Hector Pacheco, were the 2 tenants who signed a lease with my client for this Burton Drive condo property. It's undisputed that the lease began March of 2023 and was set to go through March of 2024. It's also undisputed that she paid a security deposit of $1,912.50, or both of them together did, I may say. And of course, the lease indicates that from the security deposit may be deducted unpaid or accelerated rent, and that's the same thing that the Texas Property Code, Chapter 92 states. And lastly, I'll just point out that the lease did contain, as it's supposed to, notice to the tenants that Chapter 92 of the Texas Property Code does give the right in the situation where there is family violence that a tenant may, provided that they satisfy the provisions of that statute, may be able to terminate the lease early without penalty. So none of that is in dispute. So I don't know if I need to admit defendants one, but I'm admitting it for purposes of today.
Any objection to defendants one, ma'am? It's admitted. Go ahead, sir.
Is
Thank you.
that me?
Well, yes, ma'am. I was asking you if you had any objection to the defendants
Oh,
one.
I have objections to all of it,
Okay,
but
my question is that are you disputing that that's the lease you signed?
oh, that's a question. I signed that lease, yes.
Okay, that's what I needed to know. Then it's admitted.
Thank you. Okay, I'm next open what we marked as and submitted as defendants two. Now, this is Miss Aubriana Luck sending an
Hold
email
on a
to my
second.
client.
You're admitting it, but is it attached to your motion for summary judgment?
Yes, yes.
Oh, well then, okay. I don't really need to go through that in terms of that. That's just part of your proof, correct?
Oh, okay. All right. That's fine. I just wasn't sure. I've seen different
No,
courts
that's
do it
fine.
different ways.
If you proved it up with your summary judgment, then it's just part of your proof.
Okay. All right. Then in that case, everything that I'm going to be going through has been submitted and attached with our motion. So this is defendants two, which we submitted with our motion. As I'm circling here, this is an email that she sent November 3rd of 2023. So at the start of November of 2023, keep in mind that she would have still had 5 months left on the lease, which was supposed to go through the end of March 2024. This is the first time that she gives notice and says, I want out of my lease, and says, I got attacked by my roommate last night who threatened my life. She also goes on to basically complain about all kinds of repair and remedy conditions that she says were not being done. Refrigerator, dishwasher. She complains about the unsafety of the neighborhood. She claims that there are drug dealers, homeless, and prostitutes in the neighborhood. She complains that somebody tried to deal drugs to her roommate. So just a variety of hodgepodge of complaints. I'm next putting up what's been marked as defendants three and also submitted with our motion. This is 5 days later on November 8th, a very strange and cryptic thing. She says, a murderer left a note in my car. Let me out of my lease. Okay. Now, what I'd like to do is, I'm not submitting these as exhibits, but this is actually instructive. Texas Property Code, Chapter 92. Let's dispense with the easiest thing first. This is the stuff that has to do with repair and remedy. This is Section 92.056 of the Texas Property Code. And the highlighted parts are what are really relevant to this claim that the plaintiff is making. If she were staying in the apartment, the Texas Property Code says she can follow the repair and remedy things, which is that if the landlord does not repair conditions, she can either repair them herself and deduct that from rent, or she can seek judicial damages for unrepaired conditions. However, if she decides to terminate the lease and leave early, this part that I'm circling right here is crystal clear that if she elects to terminate the lease and leave early, she is not entitled to go back and seek any other repair and deduct remedy damages or any of the judicial remedies. So in other words, after she leaves, she can't go back and seek damages for all the ways that she believes that the apartment complex was terrible, uninhabitable, conditions that weren't repaired and remedied, etc. There's good reason for that, Your Honor, because if tenants could do that, whether they went full term or whether they left early, if they could go back and sue for all the ways that they felt that the apartment was just terrible, God help our dockets, they'd be clogged beyond repair. So she made the decision to leave early. She can't go back and sue for all kinds of repair and remedy type damages. So that's the reason why, as a matter of law, pursuant to the Texas Property Code, that portion of her claim has to be dismissed. Now, moving on to the domestic and family violence termination exception, again, I'm going to put up a portion of the Texas Property Code which talks about that right. Now, a tenant may terminate
Really quickly, what date did she leave the apartment?
at the end of November, so prior to December 1st.
November of 2024?
No, I'm sorry, November 30th, 2023.
Okay.
The lease went from March 2023 to end of March 2024.
Okay, thank you.
Thank you. Okay, so in order to invoke the right to terminate early because of domestic and family violence or assault, a tenant has to provide any one of 7 categories of documentation that are all spelled out in the property code. They have to either show that they have a temporary injunction under the family code, an ex parte order, a protective order, an order of emergency protection, or a documentation from a licensed healthcare service provider who examined the victim, a licensed mental health service provider who examined the victim, or an advocate under the family code who assisted the victim. If they are able to provide any one of those 7 categories of documentation, and they give notice that they are seeking to terminate the lease early without penalty, the landlord is required at that point to go ahead and let them out of the lease without further obligation. There's no dispute about that. However, that's not at all what happened in this case. This, after my client asked, okay, you say that your roommate attacked you and threatened your life, what documentation do you have? She provides a general to whom it may concern letter from the Austin Police Department, and it says that on November 2nd, 2023, she reported a disturbance involving her roommate to a police officer. And that's it. And that is all that this letter says. So it doesn't indicate that there was actually an assault or violence. It doesn't indicate who perpetrated it. It doesn't have any of the information that's required under one of the 7 categories of documents that are spelled out on the Texas Property Code. But it gets even worse, because if we go ahead and we open up what's been marked and submitted as Defendants 5, this is where she gets extremely sketchy and extremely evasive and dishonest with regards to this whole event and her desire to leave. If you notice here, Your Honor, this is now the end of November, November 22nd, 2023. She's indicating that she wants to be out before December 1st, so she wants to be out at the end of the month of November. She says, Hector and I need the document to terminate the lease. So she and her roommate are seeking to get out of there together, and she signs off the email as Aubrey and Hector. If she's trying to invoke the statute and say that allegedly her roommate is the one who attacked her and threatened her and subjected her to domestic and family violence, she is allowed to terminate the lease early, but not the 2 of them together. She and her would-be alleged assailant can't together terminate the lease and leave together. That's a flagrant misuse and abuse of the statute. She is saying you are interfering with our moving and termination process. That's clearly what her email says. Naturally, my client is confused and says, wait a second, who is the roommate that perpetrated this assault? You're saying Hector and you need to move out, but wasn't Hector the only roommate? I'm confused on this. Exactly. And he goes ahead and he notifies her that this is what the statute says, and this is how you have to proceed under the Family Violence Termination Statute. Miss Aubriana Luck is very sketchy and evasive in the way she responds to this. She says, oh, well, the police report has that information. I don't have it. Well, my client wasn't even asking for the police report at that point. He was just asking her to answer the question, who do you say is the one that assaulted you or committed family violence against you? Again, my client asks her, I need a better understanding on what occurred. Who was involved? Did you have another roommate? You and Hector were the ones on the lease. So who is it that you're saying assaulted you? My client at that time went ahead and gave her exactly a carbon copy in the email from the Texas Property Code, Chapter 92.016, saying you have to provide me either one of these 7 categories of documentation. He's asking, was this a roommate, a guest, a family member? Who? Who assaulted you? Was there another occupant that I'm not aware of? She's very sketchy and deliberately evasive and says, no, not a tenant. And she says, oh, they haven't released the police report to me, so I can't provide any details. That's being deliberately evasive and withholding. My client responds that you have to provide me this documentation, otherwise I can't let you out for domestic and family violence, early lease termination. Then she turns around and muddies up the issue and says, oh, now you want to challenge our lease termination, and then starts bringing up all the property damage or repair issues. You guys refused to maintain the property. The apartment was not peaceful, quiet enjoyment, was not habitable. You guys didn't fix the locks, the fridge, the dishwasher, etc. My client reminds her, mutually agreeing to early termination is one thing. Forcing a termination due to family violence is another thing. So here's what it comes down to. She went ahead and left at the end of November, prior to December 1st. She and Hector together. At no time did she ever identify who it was that supposedly assaulted her, and she actually said in that email, no, it was not a tenant. In other words, implicating or implying that no, it was not Hector that did it to me. I would like to point out, Your Honor, because one thing that doesn't appear in the fact record is something that finally came out at the JP hearing, in which she was finally forced to testify under oath and answer this question to the JP judge. And she did finally admit that, yes, it was Hector who assaulted me or threatened me or whatever he did. So what that means is she is claiming that it was he, her roommate, who assaulted her, yet she and him together terminated the lease and moved out together. Again, that's a flagrant misuse and abuse of the statute. That's not the way it's supposed to work. If she wants to say that he attacked her, she's entitled to give notice and say that she wants to leave early, provided she gives one of those categories of documentation, which she never did. But they don't get to conspire to leave together and both of them be released from all liability. So the reason I find this so offensive is that this is such a disservice to so many women who actually are facing real domestic violence and abuse situations and actually have to flee abusive situations, not for them and their boyfriends together to hatch up a scheme where they can both terminate and leave together, the so-called victim and the so-called assailant leaving together. Okay. So that takes care of the domestic and family violence termination. As a matter of law, she totally misused the statute, failed to provide any of the documentation required by the statute, and abused it by trying to leave together with her boyfriend. That's not the way the statute is supposed to work, and that's not the way it's supposed to be invoked. The last thing is the security deposit claim. Now, I'll go ahead and I'll open up the operative portion of the Texas Property Code that deals with security deposit. And I'm sure you're well familiar with this, Your Honor, but again, Chapter 92, Section 104 says that the landlord does not owe any itemized description or list of deductions or any kind of an accounting if the tenant leaves and owes rent when surrendering possession of the premises. She and her boyfriend left November 30th. There were 4 more months left on that lease: December, January, February, and March. That's 4 months of rent that my client was unpaid, and they were absolutely entitled to withhold the security deposit and not provide any kind of an accounting or refund. However, I would like to point out that because of all the stink and fuss that Miss Aubriana Luck raised and threatening and then actually filing a lawsuit, she went ahead and she filed this lawsuit February of 2024, 3 months after leaving the apartment. My client, in just a small attempt to placate her, and we've already attached this as Defendant 6, they did not owe her anything. But in an attempt to placate her, they said, okay, fine. We'll go ahead and we'll take your $1,912.50 security deposit and we'll deduct an amount for, the fact that you actually had 4 months left under this lease, but we'll go ahead and we'll deduct a third of that amount, and fine, here's your check for $1,147.50. And that was sent to her at the forwarding address that she gave, which was this New Gracie Farms Lane address, where she and her boyfriend, the one who so-called assaulted and assailed her, both went. And she still was not happy. She's still suing for 3 times the security deposit, and she's suing for all the damages that she claims were not properly repaired during the time she was living there. And she has the gall and the audacity to say that she validly terminated the lease due to domestic and family violence. It's the most bad faith lawsuit I've seen in quite a while. And as a matter of law, she has failed on all 3 of her claims, and my client is entitled to summary judgment. And the only thing that should be left is the attorney's fees. What we've already submitted as Defendant 7, and what I just have to update for the additional time that's been spent for preparing for today's hearing, these are true and correct copies of all the attorney's fee billing statements that I've submitted to my client. If I have to give a quick testimony for myself, it's that I was licensed to practice November 1st of 2000.
Well, hold on, let me swear you in.
Okay.
You shall only swear or affirm the testimony you're about to give in this cause. Well, you can't do that.
What?
Hold on. Do you have, is that also a part of, are these documents you have a part of summary judgment and you've
Yes.
proven them up according to the normal way you have to prove up attorney fees?
Yes, Your Honor. I submitted an affidavit with all the attorney's fee billing statements.
Then
And
that's fine. You don't have to go through.
all that was attached to the motion. The only thing that I need to add up is the additional time for today. So everything up until today's hearing was $2,730. The additional time that's been spent for final review and then conducting this hearing today is 1 more hour. So at my reasonable and necessary rate of 300, that would bring the attorney fees up to $3,030. And that's what we're requesting on top of summary judgment in favor of my client.
All right. Miss Aubrina? Aubriana? Yes, ma'am. Go right ahead.
Can I share my screen?
Sure.
Okay, I have to join on the other side. Just 1 second. So if I can go ahead and read my statement while it's joining over here. Good morning, Your Honor. My name is Aubriana Luck. I'm representing myself. In this matter, I'm here responding to the defendant's motion for summary judgment, asking respectfully that it be declined because they failed to meet the burden of proof that they are entitled to judgment as a matter of law. And there's significant unresolved factual issues that require to proceed to trial. If not, we can't move past it. First, they failed to return my security deposit within the required 30-day time frame, as stated in 92.103. The deposit refund was delayed for months, dated March 18th, 2024, and I did move out by November 30th, so nearly 4 months later, well beyond the statutory deadline, and it was never received or cashed. I will say one thing is the check was addressed to both of us, and I live alone. I haven't talked to him since then. And I know that he kept talking in there about how we left together. We both terminated the lease and went our separate ways. Additionally, the defendant didn't provide the list of deductions violating 92.104. Based on the violations, I'm entitled to the full refund of my security deposit, statutory damages, and 3 times the deposit, and reimbursement of court fees. The second thing is the lease termination on family violence. I terminated the lease under 92.016 by providing a letter from the Austin Police Department victim advocate. And in an email, which he did not show, it talks about, and I'll show this here in a second, as soon as I can get it pulled up, but it says, I've been assisting Miss Luck with this very unfortunate circumstances in regards to her car and assault by her roommate. The online database you are able to access only currently lists as family disturbance, as that is what patrol officers originally entitled the report incorrectly. It has now been forwarded to our domestic violence unit and assigned to a detective to be investigated as assault by contact family violence. I am unable to provide a copy of the full report as we're unable to release that to anyone, even victims, and the open records request must be filed. Please let me know what other information I may be able to provide to assist with this process. And then after that, the guy from the property management company said, okay, thank you, that will suffice. So I'll show that here in a minute. I'll finish my statement and then I'll show it. See. So the defendant initially accepted this documentation, which led me to reasonably rely on their representations that they did not need anything else from me. Later, they rejected it without cause or notice, causing undue confusion and harm. I'm sorry, I'm sick, so my voice is a little bit weird. The statute allows tenants in situations of family violence to terminate their lease, and I fulfilled all the requirements under the law. The third is the breach of habitability. The defendant, I don't know the defendant or the Johnny Johnson failed to address the critical maintenance issues during my tenancy, including broken locks, unsafe windows, lack of cold water, and non-functioning appliances. These violations materially affected my health and safety, breaching the implied warrant of habitability under 92.056. Despite repeated notices, they were never resolved, leaving the property unsafe and uninhabitable. So what I'm asking for is to deny the motion for summary judgment and to give me my deposit back multiplied by 3, or even if I just get my deposit back, I'm okay with that. and the court fees. And so I would like to show, so I'm gonna move this, if it'll work. I'm really sorry. I wonder if I can just show it here. My microphone doesn't work on my computer. Man, that's really hard to see. You probably can't see that, Judge, can you?
Not really.
Okay, let me see. Are we able to pull up the response to summary judgment or no? Because I submitted it to the court.
Well, if you submit it to the court, we have a copy.
Would we be, sorry, would we be able to pull that up?
Yes, I think we can.
Somebody able to do that?
She's working on it now.
Okay, thank you. I'm so sorry. This computer is not good. Thank you. Okay, so if we scroll down, if we disregard the top part, because I already talked about it. So if we go to page 10, all right, and then on page 10, all of the requests were canceled and they were never, let's see, my continued requests for my lease to be terminated. If you keep scrolling down to page even 11, no cold water anywhere in the unit. It's been a problem the whole time. The water isn't sanitary. None of my issues are addressed. The fridge isn't cooling properly, spoils food, has been noticeably broken for 5 to 6 5 to 6 months now. Sorry. The locks don't work properly, not safe. There's a gap in the door. Problem started when my apartment was broken into. The locks were changed without my permission 5 to 6 months before. There's just a huge list. I won't get into all that because that's beside the point. My point is, if you scroll down to page 15, which is what it was. So this is that paper that Stephanie Burgess, the Austin Police Department Victim Service Supervisor, who is a licensed victim advocate, who was working with me and took on my case. Then if you scroll down, I sent that email where I talked about getting attacked by my roommate. And then all that stuff he already went over. So if you go to page 18, that's the email that Ollie, the lawyer, did not show, which is that blue, and it says that it was originally listed as family disturbance, but it was being investigated as assault by contact family violence. And I did not have the records, and she did not have the records. And so whenever I was asked, and that's what I said, was that I didn't have it. And if you scroll down one more page to 18, at the very top of it, it says, "Okay, thank you. That will suffice," by the property manager, Scott McManus. So if you take everything out, then it just goes to show that I was let out of my lease by family violence based on what they accepted as the family violence ordinance. So I should be entitled to my full security deposit, and as it was not given, and I still have never received it. But the check that they listed, which again, they listed our names together. I did not ask for their names to be listed together. And I live alone. I haven't talked to him since then. So that would be my thus far. I did attach the check on page 20, which is dated March 18th, again, almost 4 months later, and then the rest of it is just the property code. Thank you.
All right, thank you. Mr. Qatar?
Yes, just a couple quick points of rebuttal. Number one, that letter from Ms. Burgess of the APD, as a matter of law, is not one of the 7 categories of documentation that's required by Section 92.016. I've submitted the statutory language to the court. It does not describe the family violence. It's simply a report of disturbance. That's it. Number two, let's assume for the sake of argument that it was one of the, sufficient categories of documentation. That would only allow her to terminate the lease. It would not allow the two of them to terminate the lease together and leave together, which is exactly the stunt they pulled. That this is a key point. I mean, I'm amazed that she has the audacity to make this argument.
Well, but here's my question. If you're telling me this is, there seems to be, how is that in there not a discrepancy or a fact issue as to whether or not they left together?
Because all of those emails that I showed you, Your Honor, is when she kept signing on behalf of both of them saying, we need to leave, we need our termination to move forward. That was the email trail that I submitted to you, in which she said, you're interfering with
I
our
read it.
termination
I'm just
process.
saying it seems difficult to say without question or any testimony from Hector that if I denied the motion and then we went to trial and Hector says, no, we didn't leave together. I mean, wouldn't that cause an
Well,
issue?
she's already just testified here today, Your Honor, that they did go leave together. They just happened to go their separate ways afterwards. So my client was left without any tenant and any payment for 4 more months under a lease. She hasn't even denied or disputed that. So she just says that we went to different places, but the fact is they were not entitled to do a total lease termination, at most, assuming that she had satisfied the categories of documentation, which she did not as a matter of law. But assuming that she did, she would be entitled to terminate the lease. Hector Pacheco should have stayed there and continued paying rent. Okay.
Go ahead.
And then last but not least, when she says that initially my client accepted the documentation, again, the email trail is a very key point here. After she said our lease termination and started signing off on behalf of Aubriana and Hector, that's when my client started asking, well, wait a second. I thought you said that your roommate assaulted you. Wasn't Hector Pacheco your roommate? That's when she became duplicitous and dishonest and said, oh, no, it wasn't him. It wasn't a tenant. And then my client was left to wonder, okay, then who are you saying assaulted you? And why are the two of you trying to terminate the lease early? How can the two of you move out together and move out early if you're claiming that you were the victim of domestic assault? That's why it was never validly and properly done. After she provided that letter, and then she gave very unclear and inconsistent and contradictory and what turned out to be false communications about the fact that it was not Hector who assaulted her, and later admitted that it was in JP court, that's exactly why my client had to change its position. She never complied with the law. The two of them basically did this as a scheme to get out early and to get out early from 4 more months of paying rent under the lease.
All right. Thank you all both. I'll take it under advisement and get back to you as soon as I can.
Thank you. All right. Thank you very much, Your Honor.
Thank you.
Thank you.